The Honorables, the presiding judge and judges of the Court of Appeals of the State of North Carolina. Oh yes, oh yes, oh yes. The Court of Appeals is now in session. God save the state and this honorable court.
Good morning. Thank you, Mr. Soar. This morning we are, first off, I'm Judge Hunter Murphy. I'm your head of panel today, and with me is Judge Allegra Collins and Judge Reuben Young. We are here this morning for case State versus Ellis, COA number 19-820. We're also joined by Fred Wood, our Director of IT, and Jean Soar from our clerk's office. We have Mr. Chris Clifton and Greer Taylor here for the defendant. We'll be arguing in part, and Jonathan Evans from the Attorney General's office. Mr. Clifton, do you wish to reserve any time for rebuttal?
I would like to reserve 5 minutes for rebuttal and request that if I do have excess time from my original argument, that be added to that rebuttal time, if that's okay. Yes,
sir. Thank you very much. If you're ready, we're ready to begin.
Thank you very much, Judge Murphy. May it please the court, my name is Chris Clifton. I'm here today along with my partner, Greer Taylor, who's just off screen, representing Kenneth Jermaine Ellis. Mr. Ellis was stopped at a roadblock in Davidson County on February the 20th of 2016, and as a result of that encounter with law enforcement, he was convicted of several felonies and committed for a lengthy term in the North Carolina Department of Corrections. I would be remiss if I didn't at this point recognize some of his family who I know is watching by YouTube, including Ms. Audra Swepson, and appreciate their support of us and their staying by Mr. Ellis throughout this time. This case all started because the Lexington Police Department got permission to run what they call a checkpoint for general motor vehicle violation detection. That was set up in Davidson County and was actually staffed and participated in by members of the North Carolina Highway Patrol, the Lexington Police Department, and the Davidson County Sheriff's Department. They had a written plan in place, as is commonplace amongst law enforcement agencies in North Carolina, that they keep the headquarters of the Lexington Police Department. Based on the Supreme Court of the United States law and Rose and his progeny in North Carolina, it's become common practice for almost every single law enforcement agency, whether it's North Carolina Highway Patrol in general or a local sheriff's department, to have what qualifies as a written policy and procedure in place at headquarters. The Lexington Police Department, you'll see in the record at page 30, actually goes a step further and has an individual form that they use for each and every stop, as opposed to just saying that they're relying on what's contained at the police department. It includes a start time, it includes a stop time, and it also has blanks in various places for discretionary action taken by the person who engages the original request. Mr. Ellis was in a vehicle that night, and as he approached the roadblock, the lights were flashing in front of him. He saw several cars stop, and as he approached the roadblock at 1:39 in the morning, so 14 minutes after the end of the requested time, an officer with the Lexington Police Department put his hand up and said, "Whoa, whoa, please stop." That was Officer Best, who was the supervisor on scene. I can tell the court that this is the third appeal that we have currently pending before this court on roadblocks. We've got a constitutional issue that takes up arguments number 2 through 4 in our brief. That has been dealt with, as is pointed out in the memorandum of additional authority by this court in State versus Sprinkle. Judge Young was actually on that panel. So I'm here today to talk about issue 1, which is whether or not that roadblock comported with the requirements of Rose and other cases within the state of North Carolina, and additionally, whether or not evidence that was admitted at trial was in violation of Rules 403 and 404B. Should any of your honors have questions about the constitutionality of the statute and our argument about that, Ms. Taylor will be addressing those issues. So as I begin with the argument on the roadblock, that will be about whether or not this checkpoint, as the state refers to it, was a valid method of stopping Mr. Ellis.
Mr. Clifton, before you get into that, and this will go to the other issues, the constitutional issues as well, I have a question regarding the preservation of these issues for appeal. There was the motion to suppress, the order denying the motion to suppress. However, my review of the transcript and the record does not indicate where there was any objection by trial counsel regarding this evidence when it came in at trial. Can you point me to where in the transcript I should be looking at that would satisfy the Supreme Court's holding in Oglesby?
Judge, I would contend that in the Rose case, that the court makes very clear that when an issue is litigated, whether it's pre-trial or at the trial itself, this is actually on page 7 of State v. Rose, which is 170 NC Act 284. It would actually be at page 288 of the NC Act case, that once the court makes a definitive ruling on the record, admitting or excluding evidence, either at or before trial, a party need not renew an objection or offer a proof to preserve a claim of error for appeal. Clearly, the motion was raised before trial. The trial counsel noted his exception again at trial, and the judge made the finding in the record that he had preserved that issue.
And I guess my question still comes back to the lack of an objection when the evidence comes in. Rose predates Oglesby. So how do you get me around Oglesby and the fact we don't have an actual objection to that evidence during the trial when that evidence is coming in, the evidence from the stop?
Your Honor, we actually have a petition for discretionary review pending before the court on this very issue. In that case, trial counsel filed a pretrial motion, did not object before it was admitted at trial, and then after that evidence came in, he also didn't move to strike. Our contention is that when you've got trial counsel and they've gone to the effort of complying with the rules to timely file a motion to suppress before trial, they note that exception to the court during the trial, that's enough to preserve that issue, and this court should take it up. Even in the case, excuse me.
Go ahead. I didn't mean to cut you off there.
In a case where trial counsel may not be familiar with it really is a new trend requiring sort of an extra jump up and wave your arms at trial. Mr. Carroll was an assistant DA for 30 years. He did an unbelievable job. He filed the motion. He updated the motion. He noted his objection at trial, and I'll contend that this court, in a case like this where there are legitimate issues that were preserved, that this court can of its own motion review that, even if there's a finding that what Mr. Carroll did was not sufficient, but I would contend that what he did is.
Could you just clarify for me? You said you've got a PDR. Is that in a different case that you're talking about? It's
in a different case, and I don't, unfortunately, Judge, I don't have that file with me.
If it's not in this case, you didn't know. Thanks.
We'll be glad to submit something in writing after this is over. That is a case where the Court of Appeals found that the trial lawyer didn't preserve it correctly, and then unfortunately the appellate lawyer didn't raise it and ask for the correct standard of review by this court either. So we were requesting the Supreme Court to take it up and deal with the issue, because what happens is if trial counsel committed malpractice by not preserving the issue, and then appellate counsel commits malpractice by not getting the issue correctly before this court, you got 2 layers of MARs for someone like Mr. Ellis to go back through before this court could even hear it. So our contention would be that in a case where other issues have been correctly preserved, that this court should go ahead and deal with a case like that may have merit of its own motion instead of just saying procedurally it's defaulted. Because in a case like this, whether or not this roadblock was conducted legally and constitutionally means the difference in Mr. Ellis sitting in prison and not. The 404B issue would have a different outcome. It would be remanded for retrial without that evidence. But the issue that I'm getting ready to hopefully launch into is one that could be dispositive in this case for Mr. Ellis.
One more follow up with that, Mr. Clifton, just so we're clear. Obviously, I don't have that PDR in front of me, but is there any case law from our Supreme Court since Oglesby that undercuts that pretty clear ruling, black letter law from Oglesby?
I am not aware of it at this time, Your Honor.
Thank you.
One more follow up. Have you contended plain error on this appeal?
I'm sorry?
Have you asked for a plain error review of this issue?
Yes, we have, I believe, in our additional, in our reply brief, we have pointed out the correct standard of review on both of these issues, which on the 404B issue it's a de novo review for the coverage of 404B, and abuse of discretion based on whether the court correctly made their findings under 404B. So if there's any question at all, we would ask for whatever review this court can make, including an ex mero motu finding that it should address that issue.
But just so we're perfectly clear, that there was not a plain error request for the issues other than the 404B, correct?
Do you have? I believe the review is de novo on the constitutional issue.
However, under Oglesby, if it's not preserved, our case law has allowed us to conduct plain error review, but plain error review must be specifically asked for in the opening brief. And that's why I ask. I don't see a request for plain error review of those first issues you have, except for requests of potential plain error review on the 404B. So if I'm misinterpreting that in the opening brief, I just want to be perfectly clear on that.
We're contending that the standard of review on the checkpoint is that the standard is whether the findings of fact were supported by competent evidence, and the conclusions of law are then looked at de novo. Because as I stated earlier, the matter was litigated pre-trial, and Mr. Carroll noted his exception on the record, which was read into the record by the judge in the transcript.
All right, you can.
All right, thank you, sir.
Go to the merits. Go ahead. We've solved you enough.
So we would contend that the checkpoint was not conducted within the confines of the law within the state of North Carolina. I won't go through the 8 cases that we have to break down to get all the way to the review by the Rose Court. And the issue that is so important comes down to whether or not the checkpoint was conducted reasonably. Now, there's no doubt that the state has met its burden of establishing that there was a written plan in place. And so the 3-part test from Rose is, was there a primary programmatic purpose? And all of the North Carolina cases have found that general motor vehicle compliance qualifies. And does that advance a public interest? And clearly the case law says that it does. The issue that we have in this case is that the interference with the individual rights, which is the 3rd prong of Rose, does not survive constitutional scrutiny. The best case on this point is, and I don't know if I'm pronouncing this right, it's U.S. v. Huguenin. and that's whether the permissible purpose can still be conducted reasonably. And what we're contending is that the 14 minutes that takes it outside of the original request makes it an unreasonable conduct. There are so many cases that point out the hallmarks of what makes a reasonable stop. You look at the written plan, you look at the purpose, you look at the advance of public interest. It is still a seizure, and because it's a seizure, there has to be some sort of defined method, which the Lexington Police Department did the best job we've seen in any of these cases of pointing out that they had a written checkpoint policy that complied with North Carolina statute 20-16.3, as well as the on-site checkpoint. But within the checkpoint list itself, there are boxes where the officer can change where or not the location was. We found seven different variables that officer who was in charge that night could have changed. He could have changed locations, which is all of these sites that I'm making are to the record of the motion to suppress. On page 16, he could change locations or just in the checkpoint. On page 38, they have default language that the computer automatically populates. On page 41, it's within that officer's discretion to terminate. On page 42, it's within the officer's discretion to have other officers come and go. Page 46, again, the location is in his discretion. And even though this is just a motor vehicle license compliance point, they had a dog, which is referenced on page 18 of the motion hearing and is not brought up anywhere else during the hearing or the trial. But the fact that there was a dog out there lets you know this wasn't just about licenses and registration. And one of the reasons that the statute 20-16.3A is such a problem is that it says that you can't challenge the placement of checkpoints on random or statistical indication based on that statute. Now, the state would say that you can go back and make an equal protection argument or some other Fourth Amendment argument to try to shoehorn it. But the reason that subsection is in there, the two factors that we don't ever get and that we can't ever get by a subpoena or a court order or Freedom of Information Act, what are the race of the people that they're stopping? Where are the neighborhoods that they're putting these checkpoints? I've lived in the same neighborhood for 50 years and there's never been a checkpoint in my neighborhood.
So, Mr. Clifton, could you clarify a couple of factual points for me, if you don't mind? You started this argument talking about the checkpoint was supposed to end at 125?
Yeah, yes, sir, Your Honor.
All right. So between 125 and 139, what were the officers doing before they approached Mr. Ellis?
Based on the transcript from the motion hearing, they just plain got busy, and obviously that happens. And if the officers are out there and they've got a car that they stopped at 124 and they're still dealing with it at 135, that's okay. But what we have is two cars that are stopped. Mr. Ellis pulls up to the checkpoint, is flagged down. The officer's quote in the record itself is, "Whoa, whoa, stop." So he stopped at 139, which is 14 minutes after the end of the checkpoint. There's no reason they couldn't have waved him on. The thrust of our argument on the checkpoint, on the way this checkpoint was conducted, not on the constitutionality of the statute, but on the way this checkpoint was conducted, is that it appeared to be so buttoned up, but when questioned about it, the officer who was in charge of setting it up and monitoring it that night had discretion to move the checkpoint, apparently had discretion to end it early, and in this case had discretion to continue it. So at what point is one of our courts going to say, write your guidelines out and follow them? Every time we get into one of these cases, it's that there's some variance that we then say, well, it's okay because it was reasonable. At what point is it not reasonable? What if it was an hour later? What if they were still processing a DWI, which can take up to an hour on the side of the road, A car pulls up and then they stop it. Now, they didn't say they stopped it for officer safety. They didn't say they stopped it for a traffic violation. They just stopped it because they were stopping cars as part of that checkpoint.
So your position is, I'm sorry to interrupt. Go ahead and finish your point.
No, I was just going to conclude and say that on that issue, it's our contention that because there was a specific beginning time and a specific ending time, and because the officer who completed that form had so much discretion within that form to vary it, alter it, change it, both in time and location, that he just didn't have enough, there wasn't enough structure to make this a valid search and seizure. Initially a seizure and ultimately a search.
Okay, that answers my question. Thank you.
Sure.
Yes, so, before you move on, I want to keep talking about the duration a little bit. You know, their reasoning was that there was still a lot of traffic coming through. Why is that, or is that not reasonable to extend the duration of this checkpoint and for its original purposes of a license check? To me, this doesn't seem like it'd be any extra reason to extend the time. You knew that there'd be cars coming through when you set the time, so this isn't some reason to deviate. It's just there continues to be cars coming through the road. To me, that doesn't seem like a reason to deviate from the plan when you already knew that at 126 there'd be cars coming through if you knew they were coming through at 124. So can you talk a little bit about that deviation and why this would be reasonable based on the reason for the checkpoint in the first place?
I completely agree with Your Honor. I don't think it was reasonable. I think when they have a start time and they have an end time, they have to end. And I think the question, for argument's sake, is a lot of times they have these checkpoints and they just start at a particular time and there is no end time and they just sort of end when they want to end. Lexington has taken about 4 more steps than many of these other jurisdictions where we've seen these cases. They have this form, they fill it out on the computer. It has statistics on there based on charges. They're still running below 10% of people stop to get charged with anything. The problem is in North Carolina, you can say we're looking for Chapter 20 violations and do whatever you want to do. And that's just not right. There are at least 10 states in the United States that do not allow checkpoints at all because this wasn't a checkpoint. This was a roadblock. They stopped every single car coming through, including cars that were outside the scope of the original request.
Thank you, sir.
Thank you, Your Honor. So after the stop, Mr. Ellis cracks his window, holds his license out, and then leaves. And he gets chased. The officers say that the reason they gave chase was because they had a reasonable suspicion of a drug violation due to the odor of marijuana. Well, this is a case from 2016. All of the fun new Institute of Government reports and even SBI has a memo out about what that odor means anymore. In North Carolina, it doesn't mean anything. I don't know if it's retroactive back to that time, but I would point out to this court that in 2020, given the same facts and circumstances, a car pulls up outside of the time, hands his license over, and then continues on. I don't think they can follow because of the odor of marijuana. Hemp is legal in North Carolina now. They smell the same. They have the same chemical structure. There's not anywhere in North Carolina to even test if the substance is marijuana or hemp. So I would contend that just the following at that point is a problem. To speed it up, because I'm getting short on time here, when we get to the 404B issue, Mr. Ellis has been stopped. The officers go back and walk the route 0.7 miles. They find a firearm. They charge him with possession of firearm by a felon, which he has been convicted of prior to this, as well as felony flee to elude. The state at trial, I would contend, goes overboard in trying to admit the evidence of the previous conviction for possession of firearm by a felon. They already are getting in the fact of the prior conviction because they have to use that to establish that he can be guilty of firearm by a felon by proving the prior felony. He was convicted of possession of firearm by a felony in I believe, Sampson County several years before this. So the entire point of the Fifth Amendment is the right against self-incrimination, and our rule of evidence 609 points out the fact that if you take the stand, the prosecutor can and will ask everybody who gets up there, what crime, if any, have you been convicted of within the last 10 years for which you could have served 60 days or more? We hear it in court every single day. That's the first question you ask anybody on the stand. The point of the Fifth Amendment is you don't have to get up there and open yourself up to that. The state gets around that in this case because they can choose to use an element of the prior conviction to prove possession of firearm by a felon. The possession in this case may be tenuous to some, maybe not to others. There's one person who says he threw it out of the car. It's a lay witness, female, who gave a verbal statement, which was reduced to writing, which she then signed on the night of it. She didn't say anything about a gun being thrown out of the car.
However, based on the officer's testimony, the location it was found was the only place where he deviated from his lane of travel. Isn't that correct?
That's the officer's testimony. It's not completely consistent with another officer's testimony about where the deviation came and which hand came out of the window. But yes, there is some evidence there that the state can rely on to say that gun was near where the car was. And the state had every right to get in the fact that he had been previously convicted of a felony, but they go the extra step in this case and bring in the officer from Sampson County to testify about the facts of that case and use 404B to shoehorn that testimony in. The state may have been okay just with the possession of firearm by a felon as a previous conviction to establish that fact for the jury, but they went too far. They went too far because the only similarity is that there was a gun in both places, and they argue, strangely, they argue in their closing that the point of the 404B evidence is that he had a motive to flee before, he has a motive to flee this time. They didn't have to prove motive. Trial counsel admitted that he fled. The only question before the jury was whether or not he possessed a firearm and whether or not the fleeing was a felony versus a misdemeanor.
Let me ask one thing regarding some of what you're bringing up regarding, his right not to testify and the impeachment use. At trial, your client never offered a stipulation, correct, as to the prior felony, or did he?
They did not offer a stipulation until after the state had rested. Then they stipulated to it at the sentencing. A question that we've had internally is, what if trial counsel had stood up in an opening statement at the very beginning and said, my client doesn't contend he didn't flee, he just contends it wasn't a felony plea to elude? Does that change the calculus on it at all? So the state had everything they needed in this case. Why take this extra step and bring the officer to testify about that? And we can talk about temporal proximity, we can talk about similarities. The only similarity is that he fled, and what they're using it to prove in this case is that he possessed a weapon. Not that he had a motive to possess it, not that he had the intent to possess it, that he actually possessed it, because the one hole they felt like they might have at trial was whether or not he possessed that firearm. And so they just wanted the jury to say, well, he possessed it before, he possessed it again, which is the entire point of 404B. It probably, excuse me.
Sorry, go and wrap up. I'm just going to let you know you're into your rebuttal time. I just want to give you the heads up on that.
Thank you. Briefly, it is probative that he had that gun before, but it's unfairly prejudicial for the state to be allowed to offer that evidence before a jury, because whatever question they had about who might have thrown that out the car window that night, they cleaned up by using this other evidence, and we would contend that the prejudice outweighs any probative value that it may have had, and that it wasn't offered for any legitimate purpose. And I will reserve the last 4:10 for rebuttal.
Thank you, sir. And Mr. Soar, before you start the clock, just a couple of housekeeping things in the transition, since we are doing this virtually. During rebuttal, you may want to switch out with co-counsel, because I would like to hear about the proper standard of review for the freedom of travel as it relates to Justice O'Connor's concurring opinion in Attorney General of New York versus Soto Lopez, found at 476 U.S. 898, that my research does not show that North Carolina has addressed what that standard of review is since this case came out. And I know that's being handled by co-counsel with you. And then additionally, Mr. Evans, we're going to give you an extra 2 minutes on the clock. The clock did not start immediately when we got transitioned into the real session here. So defendant was given an extra 2 minutes, so we'll allow the state the additional 2 minutes as well.
Thank you, Your Honor. And I do want to apologize. I used the raise my hand function to try and acknowledge that with being as respectful as I could to counsel and not jumping up during his argument, but more so just to make sure he was not stopped in the middle of his argument or taking time away or anything like that. So I do appreciate that.
Thanks, sir.
And if I may begin. All right, thank you. May it please the court, my name is Jonathan Evans, Assistant Attorney General, and I represent the appellee North Carolina in this matter. This appeal seeks review of areas properly within the trial court's discretion and decision. However, defendant also submits arguments that improperly misapply constitutional protections and requests meritless relief that would lead to widespread unconscionable effects. The defendant challenges the denial of his motion to suppress, which sought the suppression of the checkpoint, in this case on the grounds that it was not conducted pursuant to established constitutional parameters. The defendant further challenges the constitutionality of the checkpoint under the premise that the authorizing statute, General Statute 20-16.3a, is unconstitutional on its face based on the Privileges or Immunities Clause as well as the Equal Protection Clause. Finally, defendant alleges that the court erred in admitting 404B evidence during trial concerning his prior arrest and conviction, which was allowed on the basis of proving the motive of defendant given the similarities of his actions in this case. As mentioned, one of the main aspects of this appeal is that the defendant seeks judicial review of the constitutionality of the checkpoint. However, based on the facts before this court, the defendant is not entitled to this review as he was not subject to the checkpoint. Therefore, defendant's motion to suppress was improperly denied, and review of the checkpoint is unwarranted and unnecessary. This goes to the lawfulness of the admitted evidence, and additionally, it has been since admitted by defendant in his brief, where it reads, in the instant offense, defendant never fully stopped for law enforcement's checkpoint, but kept driving. In this case, the defendant did approach and stop within the checkpoint at the direction of officers. Upon request, he provided his driver's license. However, when Lieutenant Best approached the driver's window and asked him to place his vehicle in park and inquired about the odor of marijuana, the defendant did not follow directions and drove off. The state cites in this case to White v. Tippett, where the defendant in that case, again, came upon a checkpoint and was directed to stop by an officer. He did do so within the operation of the checkpoint and stopped and remained in that spot for at least 15 to 20 seconds. Eventually, he then drove off before encountering law enforcement and was pursued and stopped a distance later. This court, that holding, determined that the central holding of Rose and Burroughs concerns the constitutionality of certain types of checkpoints, and thus applies only to where the petitioner or defendant has in fact been stopped at a checkpoint. Here, petitioner was not stopped at the checkpoint, and as such, the arguments are irrelevant. While the comparisons of this case to White v. Tippett do relate potentially similarly to the facts in this case, the case before us is closer and more likely viewed under the analysis of the constitutionality of the checkpoint, given the resulting actions that did take place. Again, the defendant challenges the constitutionality of the checkpoint, which is the subject of his filed pretrial motion to suppress. However, the state would, as was previously indicated, I'm sorry, Your Honor.
Before you transition into the constitutionality, I just want to talk about the seizure here. Why is there a seizure upon the state taking possession of his license? At that point, obviously, he's not free to go to continue on the road without his license. And a lot of our cases have talked about, when the license is given back, then, that part of the encounter comes to a cease. It's almost like you have an initial unlawful detention or physical arrest and somebody breaks out of a hold. We're still dealing with that initial seizure, not what necessarily came around factually later. So I guess I have problems differentiating this case from, or comparing this case to White, because here the officers actually had his license at the time that he left the checkpoint.
Yes, Your Honor, and certainly I think even the state would contend that the facts are not exactly the same. There was certainly more interaction with the law enforcement in this case versus in the case of White. White being a matter that is on the spectrum closer to an interaction where the person was actually stopped and gave into the authority of law enforcement while within the parameters of the checkpoint. Certainly we'd look at other cases where somebody just drives through or turns around and avoids them and things along those lines. We certainly do here have more interaction where they did give into authority in some way by stopping, giving the driver's license. And then it wasn't until a further interaction where they told the person to put their vehicle in park and that they were inquiring about what they noted to be the motor of marijuana that the person then drove by. So I think it is a reasonable argument to compare to the facts of White v. Tippett, but even the state would contend and concede that the facts here do deviate in that respect, and there is certainly more interaction.
So, Mr. Evans, talk to us a little bit about the authority of the officer or officers to stop Mr. Ellis at 139 when the checkpoint was designated to end at 125.
Yes, Your Honor. Looking at what has been previously discussed and was certainly briefed is the test to determine the constitutionality of the checkpoints. It is a two-part test. The first looking at the primary programmatic purpose, which I think in this case has been determined by the trial court. And we can certainly go into what it was, but it was stated and found to be for the determination of Chapter 20 violations and further driver's license and registrations as a checkpoint where they were checking those. Going to the second part then is of that same test determining the constitutionality is the reasonableness of the checkpoint given the individual characteristics. To determine that, the court must weigh the public's interest of the checkpoint against the individual's Fourth Amendment privacy interests. Those include the factors that, as counsel indicated from Brown v. Texas, were the gravity of the public concerns served by the checkpoint, the degree to which the seizure advanced the public interest, and the severity of the interference with the individual liberty, that last one being how the checkpoint was conducted. And while it would be, while I would like to jump into the time issue, it certainly does have to be looked at in the totality of this entire test. Again, we have the concern as far as the public concern and why this checkpoint was conducted in the first place. It was a recognized public interest. As long as the checkpoint falls under one of the Edmunds exceptions as stated in Rose, the prong will likely be met, but there must be admissible evidence of the supervisor's purpose presented in order to justify the checkpoint stop. We have that as far as the testimony in this case. I don't know that the supervisor has to testify in every case, and that's not a requirement of Rose, but certainly we have the evidence in this case through the lieutenant, then Sergeant Best, describing that this was for determining Chapter 20 violations. They were picking a location that they would be able to do so at that time of night, and they were checking licenses and registrations, which would be pursuant to that. With respect to the appropriate tailoring of the checkpoint, which is that second issue, we have to make sure that without the tailoring, it could be possible that the roadblock could be established to check licenses located and conducted in an area where that would not actually be taking place. Some of the factors to look at would be the police spontaneously deciding to set up a checkpoint on a whim. Any offered reason why?
Can I jump in for a minute?
Yes,
So
sure.
it seems to me that we could look at this checkpoint under all of those tests and say perhaps that the checkpoint was reasonable, but we're not talking about the checkpoint being reasonable. We're talking about behavior that didn't comply with the reasonable checkpoint, correct? So what standard do we look at there when somebody does not comply with the reasonable checkpoint, as happened here when the officer stopped the lieutenant 14 minutes later?
I'm sorry, Your Honor. I had a little hard time. I just want to make sure I'm focusing on the right person complying with the checkpoint. Are you asking about the sergeant, the supervisor, or the defendant?
The officer who stopped the defendant 14 minutes after the checkpoint had expired, correct?
Understood. Yes, Your Honor. I apologize. I just want to make sure I could clarify and didn't speak
Yeah,
to the
no,
wrong.
I know you can't hear me very well because my computer's loud. Sorry.
That's fine. Thank you, Your Honor. With respect to the third factor, the severity of the interference with the individual liberty, as discussed, it's the how it was conducted. In looking at an extension of the checkpoint like we have here past that brief 14 minutes past the end of it, everything has to be taken as a single fact in the determination of the factors of this case as far as it being reasonable. The The balancing of the first two factors to determine the public concern and the tailoring were conducted in a way to not unreasonably interfere with the privacy interests of the individuals passing through. And the courts require the restrictions on the discretion of the officers conducting the checkpoint to ensure the intrusion on individual liberty is no greater than necessary to achieve the checkpoint's objectives. And there are a number of factors that are described in VZ, talking about how it was conducted, what the pattern was, if it was pre-selected, if there was a starting and end time, if there were oral and written guidelines, if there was a form of supervision, if a supervisor was present, all those different factors. At the very least, the state agrees to the purposes of this protection. This does not mean, however, that every slight nuance, addition, or amendment must be due to unfettered discretion, nor does it mean that the individual's reasonable expectation of privacy is unjustly invaded. And that is ultimately what we're looking at when we are doing this constitutionality test. We're determining whether or not the checkpoint was conducted reasonably against Fourth Amendment protections, those individuals who encounter it with respect to their private interests of being able to travel and not being seized while they're driving on the roadway. Certainly, there is a valid basis for checkpoints to be conducted as long as they are done pursuant to the constitutional parameters. What we would state in this case is that a brief extension of the checkpoint, even 14 minutes afterwards, does not change the purpose, the tailoring, or the interference that it has with the public individual's rights, just because it's not the exact same thing that was written in the checkpoint plan. All these things, as far as a written policy of a police department, in this case, Lexington Police Department did have a written policy, or a written plan that sets out the parameters and how things will be conducted, certainly pursuant to that policy, again, present in this case, go to whether or not this was a narrowly tailored checkpoint to serve the purposes of the public concern and the purpose in this case. In this matter, we have the information as far as the public purpose was Chapter 20 violations, or to ensure Chapter 20 compliance. They were checking driver's licenses and registrations. There has been nothing alleged to say that in this case, the officers did not do exactly what they were otherwise told to do, were doing during that 14 minutes. If anything, the extension was because the only officer that had discretion in this case, who was not an officer, but the patrol sergeant who planned and operated the checkpoint the entire time. The only deviation was that he decided to move that because they were still busy. He indicated that there was approximately, I believe, 75 or 78 cars that came through that night, which he indicated was a lot of traffic, but there was moderate traffic throughout the night. The issue of time really just goes to whether or not it violates the individual's constitutional rights. Just because there is a small change, that one fact is not dispositive. It does not change the rest of the purpose, the tailoring, or the interference with an individual's rights. It goes to only one of the factors, those being three different factors that you would consider when doing this determination. And even then, it's part of a two-pronged test that ultimately comes down to whether or not this was constitutionally, it was within the constitutional parameters that are set out. So in that respect, the defendant's main contention during the analysis is that it briefly went past that initial end time. This is not, as the defendant argues, a clear demonstration of the type of unfettered discretion that Rose warns against, nor does it convert the purpose from a determination of compliance with motor vehicle laws and into general crime control. If anything, the contention in this case has been based on the motion to suppress and some of the follow-up information, certainly not during trial, because as was pointed out, this was not addressed during trial, other than noting the objection after the finding of the motion to suppress. But during the brief, the only thing that's been indicated is that it could have led to unfettered discretion and general crime control, but there's been no evidence to suggest that as soon as the clock struck midnight, it went past the public concern of checking Chapter 20 compliance and driver's licenses and registrations, and all of a sudden to general crime control. Yes, Your Honor.
Sure. Is there anything in the record? One of the concerns I have, in addition to the reasoning of extending the stop beyond 125, was did Sergeant Best actually have authority under the written policy to make such an extension? And can you point us to that in the record? So if he was working outside of the policy altogether after 125, and he's not given authority to extend it by the policy, what is the impact of that? Or if he did have that authority, can you point me to that?
Your Honor, with respect to the policy, the written policy of the checkpoint, the written checkpoint policy of Lexington Police Department, I do not know if it is contained within the record on appeal, but the checkpoint plan is, and as described in the testimony of of Lieutenant Best during the trial, there is an area certainly of that plan that allows for deviations based on traffic that would be found, based on the circumstances of the traffic. And I believe it's on the bottom part of that plan, which is in the record on appeal, based on his testimony, that they have the ability to deviate. And to his understanding, the deviations are normally based on location. If they are conducting a checking station, and because of traffic being different than they would normally find, normally because there's less traffic, they would be able to move to a different location, and he would log that on there. But to his understanding, that was not something that a deviation of time would not be written on that plan. I believe his testimony also indicated that the policy mirrors the language or intent of the statute 16.20 or 20-16.3A, excuse me, in this case, which does allow for very limited discretion based on the traffic pattern that would be found. So while I do not have the ability to point exactly to the authority or the area of the policy, even if there was some change or some deviation to the black writing of the policy or the plan in this case, again, the policy and the plan merely have to exist. And I don't mean that to discourage or to make them lesser, but ultimately what we're looking at is the constitutionality of the checkpoint. One part of determining the constitutionality of the checkpoint is determining not only the narrow tailoring, but the interference of the privacy interests, those being factors 2 and 3 of the Brown versus Texas test. The narrow tailoring are often determined, or one of the main factors is, was there a written policy and was there a written plan? Because we need evidence of how this was actually tailored, why it was done in the way it was done, and what was the rationale for how this was to be conducted to boon that the public interest that was present in this case, but would be required under that first factor. So just because there may be a deviation from the writing or from the initial intent, as long as that is a reasonable deviation and it does not otherwise make a reasonable checkpoint unreasonable. And what I mean by that is when we talk about the extension of time, and if there is some sort of line that would be drawn as far as, is 1 second over the end of time, that therefore make it an unreasonable checkpoint? Probably not. Is 14 minutes? I don't think so. I'm sorry, Your Honor, go ahead.
Just real quick, I just want to make sure we're looking at the same page. We're looking at R30, record page 30. That's what we're referring to? Just want to make sure you're not speaking about another document that I'm not looking at the wrong thing.
Are you referring to the plan, Your Honor? I apologize.
Yes, for the plan. Is there anything else in the record that you were referring to when talking about time and the deviation? What else we have?
I believe the finding of the trial court with respect to the written findings of fact are in the record on page 38. With respect to any other exhibits from the Lexington Police Department, I apologize, I do not have the citation or the record to look at those, but to the best of my knowledge, the policy, the plan is contained within there, and I again apologize, I do not have the citation to the plan right in front of me. If I do,
but just looking at what we have here at R30, I'm looking at the first line under it's kind of part of the boilerplate. It says all checkpoint stations shall be conducted in accordance with the checkpoint policy, and then it lays out these logistics, and this entitled checkpoint authorization. So if Sergeant Best doesn't have authorization to be conducting this checkpoint after 1:25, how can somebody without authorization or power, how can that ever be reasonable?
Well, again, the policy and the plan are merely one part of the factor in determining the constitutionality. I guess to get to the crux of the question, the Lieutenant Best and Sergeant Best indicated that he received approval for the checking station. He indicated that the time would be the 2-hour window that they would reasonably or normally use for the Lexington Police Department, that they choose the 11 o'clock briefing time to make everybody aware of the operation, to make all the patrol unit, all 12 of the officers who were present under his supervision of as the patrol sergeant, And then after that, I believe 11:23 is when the checkpoint actually started. The point of the 2-hour window, as he indicated, was that was what they normally use. But as long as they have a rationale for why they're using it, as far as traffic and things along those lines, again, it's hard to say that if they go 1 second or 1 minute over, especially if they still have things going in the operation of the checkpoint, that makes it unreasonable. The approval was certainly to operate a checkpoint that night for the purposes that they did so. They chose a location based on its ability at the intersection to see. There was a convenience store that had lighting that was appropriate and allowed people coming from all directions to see it. It was a place where there were speed points that he noted that they would be able to check as far as people coming in based on those. So the point of the checkpoint, other than the primary programmatic purpose, was to narrowly tailor it to that purpose. In doing so, they created the plan based on the policy, which would take into consideration the constitutional parameters that they would have to that they would abide by. Therefore, looking at this in total, the policy and the plan are merely one part of looking at the reasonableness. And again, a slight deviation from the policy or plan, especially one that is only changed based on the discretion of the sole officer and supervisor of this checkpoint, does not show unfettered discretion that would otherwise make this an unconstitutional checkpoint. It continues to follow the rules, and the officers did not indicate, we saw it was 1:25, we stopped paying attention, we started doing general crime control, it then became some completely different thing. This is, again, the same checkpoint. It just went on further based on the explanation that he had as far as the traffic pattern. So in that respect, we would state that, yes, there is a policy and a plan that he was following, and there was a noted end time, but again, that is merely one part of this overall test that you have to look at. And in this matter, it's only been challenged on constitutional grounds as far as how it is as applied in this case. The state would make the contention, and certainly we did discuss briefly the privilege, the 20-16.3A being unconstitutional on its face and invalid based on the fact of the Privileges and Immunities Clause with the fundamental right to travel, as well as the Equal Protection Clause. The state would indicate that while the argument has been made that the issue may be preserved, because we would equally point out and contend that this was not anything raised previously. In the memorandum of additional authority that was filed in State v. Sprinkle-Surratt, there had been previous motion to suppress or at least findings and rulings by the court on that issue. In this case, it is now contended that this is a part of the analysis that was conducted as far as the validity of the checkpoint under the Constitution. The state would point out that there is a difference, and is even pointed out by the defendant in his reply brief, challenging on its face the constitutionality as applied, and the constitutionality just in general. And I guess the best way to put this is the validity of it on its face versus how it is applied. And in this case, everything that was raised previously was as it was applied. The facts individually of this case, what the defendant actually encountered, versus the just on its face value of the facial validity of this statute. And we never saw that below. So we would again contend, not only based on that initial lack of bringing this up during trial or pre-trial, and therefore not preserving the issue, this was not preserved in any way because there was other attacks on the part of the constitutionality checkpoint, especially given the fact that there has been no attack, or there's been no contention that the checkpoint violated on its, or as applied, the statute in this case. Nothing in defendant's argument on appeal was against the way that this applied against the statute.
Mr. Evans, based on State versus Grady 3 last year from the Supreme Court and Justice Earle's opinion, she acknowledges that the line between as applied and facial challenges has become very blurred. Should we allow, maybe switching horses isn't the best phrase for it here, but should we be overly concerned with issue preservation when it comes down to whether something was as applied or facial below, and now as applied versus facial on appeal, when the Supreme Court has kind of allowed that line to be blurred? Where should we stand on that in terms of issue preservation?
Well, it depends on the facts, Your Honor, individually of each case. And I think in this matter, some of the issues that we would argue that line must stand depending on the facts of the case are because if there's no ability to address these issues below, we have no way of having a hearing, gathering evidence, having findings by a trial court to determine anything along those lines. Certainly there may be legal issues that do, as you indicated, blur the line between those two. But in this matter, nothing was raised, given a fundamental right of travel, nothing was raised previously talking about racial discrimination and ability to challenge the statute during trial. That leaves the state in a position where we don't have evidence to point to as far as a trial court's determination. We have to rely on legal conclusions and case law in doing our research on appeal. Whereas, especially in this matter, there was nothing raised as far as an unconstitutionality, number one, against the statute. Again, there's been nothing to say that the statute was unconstitutional. Everything that has been raised in the defendant's appeal and during the motion to suppress has been based on the constitutionality of the checkpoint, how it was operated by Sergeant Best that night, and how there was a time deviation, that brief period of time afterwards. So while I don't think that I can provide a fundamental reason why you should draw a line in one case versus another one, I would certainly indicate in this case there was no basis to, number one, acknowledge this by the state on during trial. And as pointed out, there's been nothing until the appeal in this case, and pending a PDR or a pending PDR, especially in a different case, is not a valid reason to change the standard at this time. There was no request for plain error even on the appeal, so I think that this is really a matter that was determined afterwards, and I think is just because of looking at it differently in a lens of review on appeal versus during trial. It's unfortunately just something that both sides are at a disadvantage when there's things that you realize on appeal you could have brought up during trial. And there are avenues to address those, but certainly I think in this case that is not the case.
And would you may not have looked at this, but a couple of years ago we had a case, State versus Gray, 259, NCAP 351 at 356, where the defendant on appeal requested that we basically look at some additional facts and considerations that are being raised for the first time in his appendix and not part of the record. If we interpret that holding or that language in such a way that it's not for our consideration, would that prevent us from considering the equal protection argument altogether, or would that prevent us from considering the equal protection or the portions of the merits of the equal protection argument?
If I understand your question,
it may not be perfectly clear.
I'll try and answer it to the best of my ability, if at all possible, and please stop me or re-ask the question if I don't answer it in the appropriate way. But I would argue in this case both, more so because there have been no merits, if you will, raised in this matter. The only thing that's been argued as far as the equal protection point is that that checkpoints disproportionately affect minorities and are placed in areas that would do so. There has been no facts, no circumstances, no case law, nothing given to that issue. Certainly nothing raised as far as facts on appeal. Further, the defendant has no standing given that. So I think, again, not being able to generalize to other matters, this is not a situation where there are ample reasons to believe that during trial this is something that could have been raised, perhaps should have been raised, or something along those lines, and now are not. Again, the state would point to the case of State v. Sprinkle Surratt. There are certainly arguments that are made within there discussing the fact that while they point to specifically subsection D of the statute talking about the inability to challenge based on the location being random or statistically based, the fact that there is subsection C, which requires the law enforcement agencies may conduct any type of checking station or roadblock as long as it is established or operated in accordance with the provisions of the United States Constitution or Constitution of North Carolina. The defendant seems to think that that doesn't give them a lot of power. However, the whole reason why we go through the determination of the constitutionality of a checkpoint is because of that. We have to determine whether or not it infringes upon an individual's Fourth Amendment protection. That is why we go through everything we just discussed.
And the case you're citing to there, if I'm correct, is still an unpublished case, correct? There hadn't been an order publishing that case or anything like that since it came down.
To my knowledge, I do not believe it has been published. It is unpublished, but the reason why we bring it up is, number one, it is exact same arguments that are presented in this matter, presented in an almost identical way. Certainly the citations, the arguments as far as the legal basis are the same, and that can be found in both the briefs that were filed in the case as well as the language of the opinion. Discussing just briefly the 404B objection or evidence, that was raised. Again, the state would acknowledge that the defendant has conceded that the standard of review should be plain error, not abuse of discretion. While there was a notation as far as the exception after the motion to suppress, the judge went on to provide a limiting instruction and asked for guidance. Did not receive any. Received that affirmation by counsel, but did not receive any additional objections when it was given, or any objections or notations after the evidence was presented during trial, even after counsel or after the defendant had the chance to cross-examine I believe it's Officer Carter.
Can abuse of discretion or plain error standard review aside, can you get me there on why this has anything to do with his motive and what part of his motive?
Well, essentially, the state is proving that the defendant had the same motive in both cases, that he needed to, that he left the law enforcement encounter or was trying to deter himself from encountering law enforcement because he had evidence of drug possession and a firearm in his vehicle at that time. Both of those would contribute to the motive of the individual to not encounter law enforcement and to do whatever it took to avoid that encounter. So that is why the state would indicate that there was motive in this case. And again, even looking aside at the standards of review, the defendant is not able to show prejudice, given the fact that there was an eyewitness who was in the vehicle. Ms. Shaquana Durham testified that she witnessed the defendant throw his hand out the window in a jerking motion of the vehicle, and the defendant admitted, I had a gun. Further, the testimony concerning where the handgun was found was located when they searched that path of only approximately the 0.7 of a mile that the defendant drove, and especially looking at that path. The handgun and the holster were found just off the roadway a couple of feet and the closest driveway to the checkpoint. And the officer that found it indicated there were scratch marks against the pavement where it was found.
Can I interrupt you for a minute? I'm sorry. Are you saying that it goes to the motive as to why he drove away from the checkpoint? Is that the motive that you're talking about?
Yes, Your Honor, that the reason why he avoided encountering law enforcement at the checkpoint, other than handing him his license, was because of that. Okay. Again, the state would argue that if there was evidence already coming in for the conviction, where's the prejudice to say that this evidence wouldn't have otherwise come in? For the reasons stated in our brief, I would ask this court to affirm the defendant's convictions and find that there was no error. Thank you.
Thank you, Mr. Evans. Mr. Clifton? Mr. Clifton, you're still on mute if you're trying to speak to us.
Okay, thank you. Sorry about that. Very quickly, the concurrence in Aldridge says such evidence is admissible as long as it is relevant to any fact or issue other than the defendant's propensity to commit the crime. They used the exact same crime to show that he did it again. The case that we have filed the PDR on is State v. Zacchaeus Anthony. That was Court of Appeals 19-894, and I'm going to let Ms. Taylor address the constitutional stuff.
Thank you, sir.
Good morning, police and court. My name is Greer Taylor, here for the appellant.
Thank you, Ms. Taylor.
And I believe I understood that Your Honor had a question regarding the Soto Lopez case, if you would like to lead with that.
I would. My question really boils down to if we found that this was preserved and we decide that we're going to address it, what is the level of scrutiny that we should be applying to the statute or the checkpoint statute in general, based on what I'll say is a somewhat unclear holding, although I think Justice O'Connor does a good job of doing like she usually does and clarifying what the plurality may have been trying to say. So can you tell me what we can really take from this case in terms of the scrutiny level?
I think that what we can take from the Soto Lopez case is that dealt with an issue where you had disparate treatment perhaps being given to veterans who were moving into New York State for their military benefits. And, there she didn't find that there was a great enough interference with that right to travel to warrant a heightened scrutiny standard. Here in our instant case, I believe that we should be applying a strict scrutiny standard here because there is a government interference. We would argue that the statute as currently written is not narrowly tailored because checkpoints are a much more restrictive device utilized by the state to restrict travel, much more restrictive than your traditional methods such as stoplights and that type of thing. What we've got here really is a situation where we have a statute that, despite what the state argues and despite respectfully what this court opined in the unpublished opinion in Surratt, the arguments advanced by both the state and in that opinion were that somehow subsection C is almost like a savings clause for subsection D, and that the state still will be required to show that the checkpoint is in compliance with the United States and state constitutions, which would necessarily include provisions for equal protection. However, subsection D then, if you get into a situation where, and again, I think Mr. Clifton did a good job of pointing this out, we have a dearth of evidence really in our facial challenge as to whether or not, these are typically statistically indicated, if there could be an eventual equal protection argument made to advance an argument based on the location of a checkpoint, then that's really been taken away from a defendant because subsection D does not allow them to bring a motion to suppress or another defense based on that subsection. So I would disagree with the state's contention that the statute is unambiguous and clearly written. I think that it is, with their contention that it's, I would say that it's ambiguous and that it's the distinction there and the tension between those two subsections, I really believe, is a problem for the state. I believe it's a problem for that statute as written, and I believe that we do have a basis for a constitutional violation based on that. And for those reasons, we would ask that our client be afforded full recognition of all the issues pled today. Thank you.
Let me ask you just one follow-up on that, Ms. Greer. I'm looking at D, and it uses the word should instead of shall, and clearly the legislature knows how to do that. Is D not just an expression of legislative preference and expression of a desired policy without trying to interfere with what would be a constitutional floor?
I believe that the legislative intent behind this is something that has to be looked at in this case. And I believe in our appendix to our original brief, we provided the House bill and the Senate bills. The language regarding the motion to suppress and defense was tacked on at basically the final stage of that whole process. And there's really a dearth of evidence as to what the intent really was there. So in practice, right now, I believe your average defense attorney is looking at subsection D and saying, well, I cannot bring a challenge, I cannot bring a motion to suppress or another defense based on this subsection if I need to challenge the location of that checkpoint.
Okay. Thank you very much, Ms. Taylor. I appreciate it. Mr. Clifton and Mr. Evans, unless Judge Collins or Judge Young have any other questions, we'll let Mr. Soar adjourn court for us.
Session of the North Carolina Court of Appeals is now adjourned.
Thank you.